Hello there, my name is Toby Wilbraham and I'm a solicitor advocate based at Olliers Solicitors in Manchester. I advise in all aspects of criminal law. I did a previous video where I discussed the procedure for appealing sentences from the Crown Court to the Court of Appeal. This video goes on to discuss grounds for appealing sentences from the Crown Court to the Court of Appeal. You can't just appeal anything because you feel aggrieved with the situation. There are two specific grounds which the Court of Appeal will look at when deciding whether there's any merit for appealing a sentence. You have to be careful because if the Court of Appeal feel there is no merit to an application, simply you're just not happy with it, then you could receive an additional time period added onto your sentence commensurate with the period of time spent from applying for the appeal to it being heard. So there are two grounds in appealing a sentence to the Court of Appeal. The first and most obvious ground is that the sentence is too long. For the Court of Appeal to agree that the sentence is too long, it has to be what is described as manifestly excessive. And what that means is it's not just a long sentence, a tough sentence, a harsh sentence, because that can be justified sometimes, but it is well out of the ballpark of what you'd expect to get for that kind of sentence. Now, due to sentencing guidelines being followed by courts a lot of the time nowadays, it's very easy to assess whether or not this is the case. Because if a case falls to be sentenced under the sentencing guidelines, you can look at the categories, you can find out what was said in court about this, see what the judge found, what representations were made by both sides, and you get an idea for what sentence that person should have had. Applying that logic to a particular case, if a defendant didn't get that, got something much longer than you'd expect, then there is a potential ground for appealing a sentence on the basis it's too long. The second ground for applying for appeal against sentence is in the situation where the judge has made a mistake in relation to the law. This does happen. It's quite rare, but it can happen. An example is that a judge has used the wrong sentencing guidelines for a sentence, looked at a case but applied the wrong sentencing guidelines, or alternatively has made a mistake in relation to how long you can give a person for that particular offence. It does happen, it's very rare. One would expect the prosecution and defence representatives to point this out to the judge when the sentence is imposed at the time, but it can happen, so this can be looked at as well. So in conclusion, if you're considering appealing your sentence, I would strongly suggest you get good advice from the onset in relation to whether there's any merit before you decide to lodge an appeal, because it could have dramatic implications on your sentence. Things could get worse rather than better.